Most Americans have no estate plan. When they die, the court decides what happens to everything they spent a lifetime building. This video fixes that. You'll know exactly what estate planning is, the 5 critical documents you need, exactly what they cost, and the devastating financial consequences for your family if you do nothing. Let's get started. What exactly is estate planning? Estate planning is the legal process of deciding in advance what happens to your assets, your health care, and your family when you die, or, just as importantly, if you become incapacitated and cannot speak for yourself. It answers 4 fundamental questions. Who gets your money and property? Who makes medical decisions if you are in a hospital bed unable to communicate? Who legally manages your finances and pays your bills if you suffer a stroke or develop dementia? Who raises your dependents if something happens to you? Without an estate plan, a judge answers all of those questions for you. That court process is called probate. Probate is completely public, painfully slow, and incredibly expensive. Anyone can look up your family's financial business. The average probate costs between 3% and 7% of your entire estate. On a $500,000 estate, that is up to $35,000. That money is permanently gone, paid to court clerks and lawyers before your family sees a single dollar. Proper estate planning eliminates that process entirely. So, who needs an estate plan? If you own a home, a car, or a bank account, you need an estate plan. If you have a spouse or anyone who depends on you, you need an estate plan. There is no minimum net worth requirement. A 65-year-old stepping into retirement needs this just as urgently as a multimillionaire to protect their nest egg from being drained by statutory court fees. A complete bulletproof estate plan consists of 5 core documents. Here is exactly what each one does. Document 1, the will. A last will and testament is a legal document that states who receives your assets after you die. It names an executor, the person legally responsible for carrying out your wishes and distributing your property. But here is the most dangerous misconception in estate planning. A will does not avoid probate. A will is simply a set of instructions to the probate judge. Everything listed in your will still goes through the court system. The judge must validate the will. Creditors are given months to make claims against your estate, and your family cannot touch the assets until the judge signs the final order. Document 2, the Revocable Living Trust. For most homeowners and retirees, a living trust is the foundational document of their estate plan. A living trust does everything a will does, but with one massive advantage: it transfers your assets to your beneficiaries without ever going through probate court. It is entirely private, it is fast, and it activates immediately if you become incapacitated, not just when you die. However, there is a catch. A trust must be funded. Your home, your bank accounts, and your investment accounts need to be legally retitled into the name of the trust. An unfunded trust is a worthless stack of paper. Document 3, durable power of attorney. Estate planning isn't just about what happens after you die. It is about protecting you while you are still alive. A durable power of attorney legally appoints someone to manage your financial affairs if you become mentally or physically incapacitated. If you were in a serious car accident or develop severe cognitive decline, this person can pay your mortgage, manage your retirement accounts, file your taxes, and handle your property. Without this document, your spouse or children cannot simply walk into a bank and access your individual accounts. They would have to go to court and sue for a conservatorship or guardianship to get legal authority over your finances. That court process can take months and cost thousands of dollars, all while your bills are piling up. You must have this document in place before an emergency happens. Document 4, healthcare power of attorney, also called a healthcare proxy or medical surrogate. This document names the specific person you trust to make medical decisions on your behalf if you are unconscious or unable to communicate. Without this legal document, doctors and hospital administrators may be legally prohibited from discussing your condition with your own family due to strict privacy laws. In a medical emergency, you do not want your loved ones arguing with hospital legal departments over who has the right to authorize a vital surgery. Document 5, living will. Advance healthcare directive. A living will states your exact wishes for end-of-life medical care. Do you want to be kept on a ventilator? Do you want artificial nutrition and hydration? Under what specific circumstances would you want life-prolonging treatment stopped? This document is the greatest gift you can give your family. It removes an impossible burden from their shoulders. Instead of forcing your spouse or children to make the hardest, most guilt-ridden decision of their lives in a hospital hallway, you have already made the decision for them. Let's look at exactly how this plays out in the real world. Meet David and Sarah. They spent 40 years working, paid off a $450,000 home, and saved $150,000 in a standard bank account. Like many retirees, they went to a local lawyer and drew up a simple will, leaving everything to their 2 adult children. When David and Sarah passed away, their children thought the will meant they could simply sell the house and divide the money. They were wrong. Because the house was only in David and Sarah's individual names, the children had no legal authority to sell it. The will was just a piece of paper telling the court what David and Sarah wanted. The children still had to hire a probate attorney and file that will with the court. For the next 14 months, the house sat empty. The children had to pay the property taxes, the utilities, and the insurance out of their own pockets while waiting for the court to officially grant them access to their parents' bank account. By the time the probate judge finally cleared the estate, the court fees, executor fees, and attorney fees ate up nearly $28,000. That is $28,000 of David and Sarah's hard-earned retirement money gone forever, simply because they relied on a will instead of a trust. Now, let's look at Richard and Linda. They had the exact same assets, a $450,000 paid-off home and $150,000 in the bank. But instead of a simple will, they set up a revocable living trust. Crucially, they took the final step and funded it. They changed the deed of their house so it was owned by the trust, and they retitled their bank accounts into the name of the trust. When Richard and Linda passed away, their adult daughter, acting as the successor trustee, legally stepped into her parents' shoes the very next day. Because the trust legally owned the assets, she didn't need a judge's permission to do anything. There was no 14-month waiting period. There were no public court hearings. She had immediate legal access to the trust's checking account to maintain the house. She listed the house for sale 2 months later, distributed the funds exactly as her parents intended, and closed the estate. Total court fees, $0. Richard and Linda paid about $2,500 up front to set up the trust, and it saved their children $28,000 in over a year of severe legal stress. That is the difference between having a piece of paper and having a functional estate plan. Before we talk about costs, we have to talk about the most overlooked piece of estate planning: beneficiary designations. Your retirement accounts, your 401k, IRA, and your life insurance policies do not pass through your will or your trust. They pass directly to whoever is named as the beneficiary on the account itself. If your beneficiary designation is outdated, if it still names an ex-spouse, a deceased parent, or no one at all, that money is going to the wrong person, or it is going straight into probate court, regardless of what your brand new trust says. You must review your beneficiary designations every single year. So, what does a complete estate plan actually cost? Here is the honest breakdown. A basic will costs between $150 and $500 with an attorney, or under $100 using an online service. A comprehensive revocable living trust package costs between $1,500 and $3,500 with an attorney, or $400 to $600 online. This package typically includes the trust, a pour-over will, your durable power of attorney, and your healthcare documents. A highly complex estate plan involving multiple properties and businesses might cost $3,000 to $8,000 with an experienced attorney. Compare those upfront numbers to the average probate cost of $15,000 to $35,000. A proper estate plan pays for itself the very first time it is used. Where do you start? Step 1. Take inventory. List everything you own: your home, your accounts, your retirement funds, your life insurance policies. Step 2. Review your beneficiary designations. Log into every retirement account you own right now and confirm the named beneficiaries are correct. Step 3. Decide between a will and a living trust. If you own a home or have more than $150,000 in assets, a living trust is almost always the better choice to protect your family from probate. If you do not own real estate, and your assets are primarily in retirement accounts with named beneficiaries, a basic will may be sufficient for now. Step 4. Get it done. The biggest mistake in estate planning is waiting. The second biggest is starting and not finishing. Every video on this channel covers one piece of this puzzle in detail. The full playlist is linked in the description. Start with the topic most relevant to your situation. Comment below, what is the one estate planning question you've never been able to get a straight answer on? We read every comment, and your question may become our next video. If this video helped you, hit the like button and subscribe. Every week we break down estate planning in plain English, so your family doesn't pay the price for not knowing. I'll see you in the next one.